All right. So welcome everybody to our webinar today. We are going to be talking about guardianship from start to finish. And before we start with our presenters and the presentation and everything, let me tell you guys why we do a partner research network. Again, my name is Veronica Alvarez, and I'm the Team Project Regional 13 Coordinator, and there is my email and phone number. And for the people that just log into our presentation, please be sure your computer speakers are turned on. If you have any question, please type them on the chat box that is going to be on the right side of your screen. And also at the end of the presentation, you are going to be redirected to a brief evaluation page. We really appreciate your feedbacks and comments. And thank you and welcome again to this today's presentation. So Partner Resource Network is the Parent Training and Information Center for Texas. We are funded by the Department of Education, Office of Special Education, and we provide free resources and training for parents of children with disabilities and self-advocates. Our mission is to empower parents of children and youth with disabilities in their roles as parents, decision makers, and advocates for their children. We serve parents of children with disabilities and self-advocates. So we serve from 0 to 26 years old. This is a map of Texas, and we have 4 projects now since October the 1st. Before that, we just been founded by 3 projects. Now we have this new project called PACT. So it's the same. We are Partner Resource Network, and we've been serving parents in 1986. So just a little bit of difference between our directors and staff. You have a regional coordinator in each area serving parents. Our services are free, and we provide parents workshops, youth workshops, webinars, information and referral, one-on-one technical assistance, support at the art meetings, annual symposiums, parent leadership training, youth leadership training. Because right now the COVID and everything is virtual, but we can do it, guys. Our services are still the same, but just, virtual. And this is our main contact information in our office in Houston, team project email, and please visit our website. All right, so today we are going to be talking about guardianship from start to finish, and we have our presenter is going to be Melissa Donovan. She's a certified elder law attorney and the director of the Elder Law and Special Needs Planning at the Viewer Law Firm. She's here in Austin. And also we have back again, like the past 2 months, Alison Charber. She's a passionate advocate and leader for the special needs community. She's a licensed finance planner with over 25 years experience, and she's the owner of the Consolidated Planning Group. Allison?
Thank you so much for having us here today. We are really just glad to bring this information to you. Again, Consolidated Planning Group is a special needs financial planning firm. We work with families just like yours, developing plans for the future care of your child. Whether you're diagnosed or you're a veteran parent and you're kind of looking at transition and where we go from here, we can help you with that. But today, we are super excited to have Melissa Donovan with us. As a special needs planning firm, there's a lot of I call them buzzwords that we hear over and over and over again. It's transition, it's guardianship, it's special needs trust, it's future care. There's so many things that we hear about over and over and over again, but there's a lot of confusion that surrounds guardianship and what do I do? I've got this child that's going to be turning 18 soon, and Melissa is just going to provide us a wealth of information today and get your questions answered. We always have the question, will this be recorded? And the answer is yes, we will be recording this, this meeting today. And just to repeat what Veronica said, as we're going through this presentation, I'm going to be monitoring the chat box. So if you have questions, put your questions in the chat box. You guys are all muted, so everybody can hear Melissa quite well. But put your questions in the chat box, and we're going to get to as many questions as possible. So thanks so much. Thanks for joining us, and we look forward to serving you. Melissa, I'm going to turn it right on over to you.
Thanks, Allison. I appreciate it. So I'm Melissa. My name is Melissa Donovan. I'm an attorney here in Austin, and I'm going to ask everyone to bear with me a second as I try to get this PowerPoint up for y'all. So as Allison and Veronica were saying, I'm an attorney here in Austin. We're going to talk about some guardianship today. We always have a few kind of preliminary things that, we attorneys have to go through with you. But as Allison was saying, she is wonderful at the work that she does and helping with her clients with their special needs planning needs. But today we're going to talk primarily about guardianship. And we attorneys, we love our disclaimers. So it is important that y'all realize everything we talk about today, this is kind of provided for general information. We're not creating an attorney-client relationship here, but we do want to try to get as many of your questions answered as possible and kind of have an open dialogue. I'm a big believer in not speaking at you, but speaking with you. So as we go through things here today, like Allison was saying, please feel free to get your questions into that chat box, and we're going to try to answer those as best as we can. So, I have a lot of clients that will call our office, and it could be a number of scenarios. It could be that we've got an individual that has a parent who is slipping into a dementia type situation. It could be a situation where we have a parent calling because they have a special needs child. And one of the things that I have come to realize over time is many times people assume that a guardianship is necessary in a lot of situations where it may not be necessary. So the question I always get is really, do I need a guardianship, and kind of what does that entail, when really I think the question should be, do I need a guardianship, and is it possible to avoid it? And many times that question is yes, and we're going to talk about how to avoid that as well today. And that's what we refer to, in the court as being less restrictive alternatives. And we're going to go through all of that today. So we always kind of look at special needs planning. Like Allison was saying, people think of special needs trust and you think of these specific things, and it really is, I know it sounds cliche to say it, it is a huge team effort, and it's a lot of things that go together. So this kind of gives you an idea of everything that's kind of within the toolbox. We all oftentimes talk not just in the special needs context, but in the estate planning context and the financial planning context. You've got all these tools in the toolbox, and this kind of gives you a little bit of a reference to all of those different tools that are in there, outside of just kind of focusing on guardianship. But today, of course, we are going to focus on guardianship and how to avoid it if it is possible to do so. So the first thing is, what is guardianship really, and why would one need it? And really what it comes down to for the majority of my clients when we're talking about guardianship, we are looking at it from a perspective of a parent who has a child who is about to turn 18. And while most parents provide and take care of their kids well beyond the age of 18 these days, technically that is the legal age that your child does become an adult. And as probably a lot of us learned when we turned 18, when you turn 18, it is much more difficult for your parents to help you with things. And if you have a child who really doesn't have the ability to understand and make decisions for themselves, that's the problem that needs to be addressed, is that we need to figure out a way for mom and dad to go ahead and be able to continue to help really be the parent that they had been up until that child turned 18 and continue to do so beyond that point. If some of the ways that you can avoid guardianship in the proper scenarios, does your child have the ability to understand and sign powers of attorney? We're going to talk about that. We get a lot of questions about decision-making agreements because they're relatively new. And those are things that we would like to make sure that we kind of walk through. And usually when things are new, we get a lot of questions on them. So we're going to kind of walk through that here today. So these are the things that you are going to start when you're considering guardianship. So the first thing you want to think about is, what is the actual concern that I have? And what that comes really down to is, what is the situation that your child is in? And as we kind of go through this today, there are places where I'll kind of reference if you're working with, maybe a parent or a sibling who is an older adult, but the bulk of our focus today is going to be focusing more so on, we've got a special needs child who is either about to turn 18 or has recently turned 18, and we're going to kind of focus in there today. So the first thing you want to think about is, what is the concern? What is my child's condition? Are we dealing with a case where are we dealing with autism? Are we dealing with a physical disability? What is the situation? What do we need to deal with? And then from there, we want to talk about, is this a situation that will maybe go away or lessen the problem over time? And then also, do you have community around you to help you? So this goes back to when we were looking at that slide earlier in regards to kind of your toolkit. You want to have a good team in place. So that could be care managers, that could be social workers. Of course, that's going to be family. It could be close friends. It's going to be the people that help you help your child to live their everyday life. And all of those things are really important. So you want to make sure that you've got that team in place, and that team might be very small. That team might be very large. Every scenario is different because every family and every person is different. But the biggest thing, these last 2 points are really the biggest things. And you want to keep in mind, what is the actual capacity level for the person that you're concerned about? And what are their not only limitations, but more important, what are their abilities? I find many times in general, people, when they're dealing with being around friends or family members who maybe have some special needs concerns, people sometimes focus on the limitations that that person has. And what we really need to focus on is not what their limitations necessarily are, but first, what can they do? What are they capable of doing? Because as we kind of go through this process, you will see when you're getting a guardianships over someone, you are taking away their ability to do a lot of things. So we want to kind of avoid that if it is possible. And truth be told, most courts want to avoid it if it is at all possible to do so. So there are a couple of different types of guardianship that we're going to talk about. So as a base level, there are guardians of the person and guardians of the estate. So essentially what that boils down to is, guardian of the person is the person who is going to be in control of the day-to-day needs, medical decisions, care and custody of what the court refers to as the ward. This would be the incapacitated individual. So that's someone who's going to be almost like the court provided the court provided equivalency of a medical power of attorney, okay? Your guardianship of the estate is the person who's in charge of the money. There are very different rules in play for someone to be the guardian of the person versus guardian of the estate. And you don't always have to have both. Many times, actually, you can avoid having to go through that process of getting a guardianship of the estate, specifically when we're dealing with children who are aging up into adulthood. On the other side of things, when you're dealing with parents and the elderly, it is much more difficult to avoid that guardianship of the estate because you're dealing with someone who has had an opportunity to develop, assets and have a portfolio over time, and you may not be able to avoid it. But many times when I'm working with clients in terms of kids who are turning 18, it is actually quite easy to avoid that need for guardian of the estate. And as we kind of move forward, you'll get an idea of why we want to try to avoid that if we can. You'll see here we have full and limited guardianships. It is possible that you can say, well, the ward can do these things, but we're going to take away the rights to do those things. It is a little bit more complicated to do that because you're having to prove various levels of capacity to be able to do different things, but that is also a possibility. And then of course there is always temporary guardianship, which the way that I speak to my clients is always this. You want to, as much as is possible, think of any guardianship as being temporary, because the hope and the goal for most parents, when it is possible, is to have that guardianship and eventually be able to step away from it as the child gets older, becomes more able to manage adulthood without the constraints of that guardianship in place. So, and we kind of talked about that a little bit here. This slide is a good representation for you of if you are going to have a guardianship over someone, all of the things that you were saying, they can't do any longer. So, you know, they can't vote in an election. You're taking away their ability to choose who or if to marry. You're saying they can't manage any financial or management business activities. The big one for most of my clients is medical treatment. You are going to be responsible for making those decisions. And kind of going back to what I was saying earlier as well, with a guardianship, you are going to have to renew that guardianship on an annual basis. So that's why we say don't think of guardianship as being necessarily a permanent thing. The goal for, again, not all, but most of my clients is that eventually that guardianship is not going to be necessary any longer. And at that point, you can let the court know that, and the court can say, you're right, we don't need the guardianship any longer. You know, Sally or Jim can go ahead and they don't need you to be a guardian anymore. So we're going to take that back. And now there's no guardianship in place any longer. So guardian of the person, as I was kind of saying earlier, these are the things that you are dealing with custody. You will determine where the person lives. You will determine medical treatment. You are there to provide for those decision-making activities that don't actually involve, for the most part, finances. Now, here in Travis County, and this is different in every county. We're in Austin, so we deal with Judge Herman and his court all the time. And what they require, even with a guardian of the person, is a $13,000 bond. It's just a general bond that they require of all guardians of the person. And I've not ever seen Judge Herman waive that. In other counties, it is possible that they may waive bond or they may lower it. That's going to vary depending on the county. But as this says, you're dealing with the well-being. The way I explain it, you're continuing to be your child's parent. Everything that you were doing before your child turned 18, you're having the court basically give you the permission to say you can continue to do those things now that your child is 18. I know for a lot of people that can seem kind of strange, but that's essentially what it is at a base level. You do have to meet certain criteria. Now we have this weird thing when it comes to probates and guardianships where you're not proving that you are qualified to do something, you're actually having to prove that you're not disqualified. I know sometimes statutes are weird and lawyers are weirder, but it's kind of the way that we have to do things. So there are certain things that will disqualify someone from being a guardian. We're going to kind of go through that in a little bit. But to give you an example, you know, if someone is a felon, they're generally not going to be able to be a guardian of someone. The one that always kind of catches people, if you're in a lawsuit with somebody, you can't be their guardian, rightfully so. But you have a duty when you are a guardian. It's not just about what your rights are. With rights come responsibilities, and that's what we have. So with your duty, you are providing for the care, supervision, custody, control of the individual. You do have those powers. You do have to provide annual reports to the court. Now, on the side of being a guardian of the person, it's a little bit easier in terms of what your reporting requirements are to the court, and the court is a little bit less involved on the day-to-day basis than they would be in a guardian of the estate. Essentially, your job is every year you are reporting to the court, this is where we were, this is how the individual had been doing when we started out, this is how we're doing now. Are we still living in the same place? Are we still doing okay? Has the diagnosis improved? Has it declined? You're just letting the court know how things are going. Now, one thing I will say is that even as a guardian of the person, there are still some things that you cannot consent to by law and would require you to go back to court. Most things you can determine without having to go back to court every time you want to make a decision, but there are things that you cannot do. So for example, you can't have the individual placed into what we call a more restrictive home scenario than they had lived in at the time of the guardianship without getting the court's approval to do so. So it's not a carte blanche pass to make all decisions for that person. But for the most part, most kind of day-to-day general activities and decision-making as guardian of the person, you're going to be able to do.
We have a couple of questions. Can one seek guardianship but still allow the person to get married?
So this would fall under limited guardianships. Like I was saying earlier, it is possible that you can request the court, and if you can prove why, that you can waive that requirement that they're not able to get married. That's going to be highly dependent on the circumstances, and every situation is going to be a little different. But you can say, maybe we don't think this person has the capacity to understand, to manage money and to, vote in an election. We feel like they're easily manipulated on the financial side of things, but we do still feel that they are capable of X, Y, or Z. That's where you were kind of going into a limited guardianship, which is always a possibility. It just depends on the circumstances.
Okay, and then the next question is, can a person request guardianship to be removed even if it is within a period of time less than a year, similar to a minor child requesting emancipation? Yes.
So if it is no longer necessary, you don't have to wait until that annual review period to remove the guardianship. That's, again, it's entirely going to be on a case-by-case scenario. But if you get to a point where within that 1 year, things have just progressed to a point where that person doesn't need it anymore, then it really is your duty as guardian to go back to the court and let them know that. Because like I was saying earlier, the court really doesn't like taking away people's rights. And when you are acting as a guardian, that's essentially what you are doing. So the court is always going to err on the side of the less restrictive alternative, honestly. So if 6 months, 7 months, 8 months go by and there's a drastic change in circumstances and that guardianship is not needed any longer, then it's really your obligation to try to get it removed if you can.
Okay, that's it for now. Thank you.
Sure. So then the other side of guardianship, as we were kind of getting into it, is guardianship of the estate. So this is where, in my practice and for a lot of colleagues of mine, if it is possible, we do typically advise clients, if it's possible to avoid this, we want to avoid this. So say, for example, you have a child who is turning 18, there's no assets in your child's name, they don't have any bank accounts, they don't own anything. And maybe you're looking at when they turn 18, as many times you should, trying to get that child onto supplemental security benefits. What can happen is you don't technically have to be guardian of the estate to assist with those Social Security benefits. You can just become what's called a representative payee. So you don't necessarily have to go through the process of getting a guardianship of the estate over someone in order to maintain and be able to control that particular benefit. So if it's possible, and there's no assets in that child's name as they're turning 18, you don't necessarily have to get a guardian of the estate. If something pops up later on down the line and it's necessary in the future, then you can always go back and get it at that point in time. But what the guardianship of the estate, the guardian of the estate does is just that, they're managing assets. So the reason why many times you want to try to avoid it is, like I was saying earlier, it does involve a whole lot more court time and involvement of the court in kind of the overseeing of what you're doing. And it is more work on the part of the guardian. So here you also will have to post probably, depending on the size of the estate, a larger bond. Now, many times I'll get questions about, how big of a bond, what is the bond requirement? There is no standard statutory requirement. I can't give you a number. It's going to depend on the estate that's at play, and it's usually going to be based on a percentage, but it is going to be up to the judge in any given case to say exactly what that bond has to be. So it's a little bit different than the guardian of the person here, because it's going to depend highly on the facts of the case. You do have to provide the court with an actual inventory. So the court is going to have to be made aware of exactly what is in the estate. So that's a lot of accounting work that's going to have to be done up front, and then you have to maintain that accounting work over time. So once you qualify as guardian, then within that 30-day time frame, you have to file a request for what we call allowances. So many times I get questions where people will say, well, oh, so if I need to pay for this or that, do I need to go to the court every time I need to pay the electric bill? Well, no, you would do things like that within that allowance. So you basically, you're setting up a budget, essentially, is what you're going to look at. And the court is going to say, okay, we approve this budget. And then they will approve that use for that allowance. If something out of the ordinary pops up and there needs to be a large expenditure from the estate, you will have to go to the court sometimes, depending upon what the situation is. Also, an investment plan many times has to be filed. This is something that can be waived, but again, kind of like setting the bond, that's something that is entirely up to the judge in the case and what they feel is appropriate based on the circumstances. The thing that you want to keep in mind is anytime we're dealing with guardianship, just like in family law when we're dealing with minor children, it's always going to come down to what is in the best interest of the individual. So that's always the key thing you want to think about, is whatever decision we're putting in place, is it in the best interest of the individual who is being affected? And that's what the court is always going to look at. Again, just like with guardian of the person, there is going to be a requirement of an annual report here. It's a little bit different because, again, the guardian of the person, that's going to be a report about the actual physical well-being, placement, things of that nature. The annual accounting for the guardian of the estate, we refer to it kind of like a checkbook type of accounting. So you're having to tell the court, this is where we started financially. These are all of the receipts that came in over the year. This is what we paid for over the year. And we've landed at spot Z, which when you do all of that math from A to Z, it should all add up. And then again, some scenarios where that estate can be closed, as we were kind of just talking about a few minutes ago. So this is kind of, for some people, the fun part, but usually not. This is the process, So one thing I will say is it is a requirement when you are obtaining guardianship that you do have an attorney that represents you, specifically everywhere with guardian of the estate. What that comes down to is you're acting as what we call a fiduciary for another. And the way that the law works, one cannot act as a fiduciary for another without having a lawyer represent them in the process. So don't shoot the messenger. It's just kind of the way that the process works. But as a general nature, this is kind of where we start. So when I'm working with clients who have children who, whatever their situation is, many times I'm lucky enough to be able to start working with those families much before their child is turning 18. And we kind of go through a rundown. If I'm working with a client and they have, let's say, a 14-year-old child, and they come in to talk to me maybe about estate planning or something different than guardianship, we're going to sit down and go through kind of, this is your 5-year plan, this is your 6-year plan. You need to get this in place and this in place, and we're going to look at guardianship at this point in time. So like with many things in life, the sooner that you can start the process, the better, because things will go smoother when you have a good plan in place. But you can start this process as far in advance as 6 months before the birthday. More often than not, we don't start the actual application process that far out, but you can start the process. So with the guardianship papers, what this looks like is that you will file an application with the court. Once that application is filed, the court will appoint what's called a guardian ad litem. So when you are working with an attorney to obtain guardianship, that attorney is technically representing you in your role as trying to obtain that guardianship. your attorney does not represent your child. Now, any decent attorney, as their role understands in representing you as a fiduciary for a person, really we do have some obligations to make sure that when we're representing the things that you're trying to put forward and representing your interest is going to extend over to representing the best interest of that person, even though we don't technically represent your child. So because your attorney doesn't represent your child, the court has to appoint another attorney whose job is to look out for your child. So that's called an attorney ad litem. And what will happen is once that attorney ad litem is appointed, they're going to reach out to you and your child, and they're going to have to meet with them. They're going to have to sit down. A little bit different now. In past times, they would come to the house, maybe go to the school. They would meet your child in a place that is really most comfortable for the situation, and to make sure that they're not kind of disrupting the daily activities and the mental state for your child. They're going to meet with you. They're going to meet with them. A lot of people are doing Zoom now because of the situation that we're in currently, but they do need to be able to get a feeling. Their job is to get a feeling for how is the minor doing, how is the family situation, and is it truly in this person's best interest, and do they need a guardian? That's what their job is to look for. Now, one thing that we look at here and we mention is this item called a physician certificate. That is something that you're going to obtain that's going to go along with the application. So that physician certificate is your child's doctor's statement as to exactly what is going on. What is the condition that your child has been diagnosed with? What is the prognosis? How limited are the abilities? Are there things, we talk about daily living activities, we talk about decision-making abilities, and the doctor is really going to be there to say, this is what they are capable of, this is what they're not capable of. They're going to attest to what their IQ and kind of general capacity is. And that's what's going to kind of lead us down the road to, okay, how much of a guardianship is necessary, or maybe a guardianship isn't necessary at all, depending upon what that doctor says. So,
Melissa, we have a couple of questions, if it's okay. The first one is, when a large sum of money, home and land will be inherited, the child will not mentally improve because of their diagnosis. Is it possible for the parents to set someone to take over the guardianship when we're gone? And I'm going to let you answer that part, but the beginning part where it says when a large sum of money of home and land will be inherited. So the key thing here in this question is, if your loved one is getting SSI and Medicaid, that large sum of money of home and land needs to be in a special needs trust, or they will be disqualified from SSI. So it's very important that we address that part first. So the special needs trust is extremely necessary if your loved one with special needs that's getting SSI is going to be the one that's inheriting that. And so I'm going to turn the answer on successor guardianship over to you. And then we have two other quick questions too.
Sure. So yeah, I'm going to agree with you wholeheartedly. If you are in a situation where someone is going to be inheriting a large, really any sum of money beyond, maybe a few hundred, a couple $1,000s, you are going to want to make sure that whoever is providing for that inheritance is doing so properly. Aside from that, when it comes to being a guardian, you can always designate, you can do what's called a declaration of guardian. Now, I am very upfront with clients. The declaration of guardian is something that it is instructive to the court. Now, generally speaking, they are going to follow your requests so long as it's possible for them to do so, but they're not mandated to follow the people that you've listed there. So a declaration of guardian is a document that you can sign saying, if something happens to me, these are the people that I want to be designated as guardian, and maybe these are the people that I would prefer not be designated as guardian. We've all got that first cousin that kind of sticks their nose into everybody's business that we don't want in our business. So you can designate that person. The court will not be able, generally speaking, to appoint that person, but you can also say, this is who I do want. But I find it very important to make sure that people understand that just because you designate someone on there doesn't necessarily mean 100% that the court has to go with that list. They are going to try to go with your suggestion as much as is possible, so long as that person's not disqualified and it is in the best interest of the ward to have that person as the guardian. But again, we go back to that phrase, that best interest of the individual, and the court's always going to look to that. So it is always worth it to have that in place. It's a general thing that we make sure all of our clients do on an estate planning side of things. So to do that, especially if you have a child who you are either looking at obtaining guardianship over, or you already have guardianship, or for example, for your minor children, regardless, you're going to want to have that in place.
So the other question, it seems like it's a several part question. Would I be able to be a guardian of the person for our son that has Down syndrome he's emerging, verbal, 19 years old, and have my husband become the guardian of the estate? He will have an ABLE account and currently has just under $2,000 in his bank account. He receives SSI and is on Medicaid, secondary to husband's group policy. Do we need both? And if not, what point does the guardian of the estate become necessary, or can one person be the guardian of everything? So first, my suggestion on do we need both on the health side of things. Okay, so group health insurance, Medicaid, and group health. So what I would say is yes, do you have to? So if you're in financial straits, do you have to have both as it relates to health insurance for your child? You absolutely don't. But by having the group health insurance through the employer, it gives you freedom of choice of care providers. Typically, the care providers in the Medicaid program are limited to where they say that you can go. And granted, there might be like a PPO where you have like a network provider, but the network is much broader. You have much more choice in a group health plan than you do in Medicaid. Medicaid is going to tell you where to go, when to go, how to go. They're going to tell you what you can take and what you can't take. And if you have a child that has serious conditions, the group health plan is going to give you more choices than Medicaid. So that is my suggestion. And then the other thing that I will tell you that is important to note is that if you have a child that was disabled prior to age 26. So the law says on a group health plan that our kids get kicked off the group health plan once they turn 26. But there are provisions, and most people don't know about that, for you to keep your disabled child on your group health plan past age 26, so long as you can prove that they're disabled. Most companies don't advertise this. You have to call HR and ask if they have this provision. There's usually some paperwork that you have to do. And also you can advocate for yourself with your company. If you call and you find out your company does not have this available, I would put something in writing that they need this and that this is a growing thing that other companies are doing for their families with kids with disabilities, and ask them to add this, because that is something that's super important. So anyway, that's my part of it, and I'm going to turn the rest of that over to you, Melissa.
So going back to the part of the question about do we need both, unfortunately, I can't in good ethics say you do or do not in a situation like this. I can't give any legal advice in this presentation. However, it is to go to the basic question, is it possible to have one of you be guardian of the person, the other be guardian of the estate? Absolutely. It is also possible that you could be joint guardians of the person and just have one of you as guardian of the estate. Those are all potential possibilities. Whether or not that's going to be in the best scenario, if that's in the best interest and that fits your situation best, that is something that you really need to be able to kind of sit down with an attorney one-on-one and have that conversation in private. And unfortunately, I apologize. I can't really answer that question today. And then forgive me, Allison, but I think you said there was another part to that question that I'm.
Yes, and so let's see. We talked about the insurance. Do we need both guardian and estate? Hang on. No, I think we basically have that one, and then the last. Well, it's not the last one. Is it too late if the child's already turned 18? Someone wants to know: is it too late to get guardianship? What do we do now?
No, it is absolutely not too late. And in fact, you're not going to be able to get guardianship of your adult child until they're technically an adult. So to give you an example here, and again, this is one of those things that different courts have their policies differently, But Judge Herman here in Austin won't allow you to even have the hearing until at least a week after the child's birthday. So it's never too late. You might be in a scenario where your child turned 18 and for a little while, doctors were working with you and schools were working with you, so you didn't really think it was necessary. And then all of a sudden, kind of like this sometimes is what happens. People stop talking to you, and then you need to think about getting the guardianships. It's never too late to get the guardian. It can be too early, but it's never too late if the situation arises.
Okay, and then so one more. Let me see here. Okay, so Angie was just talking about both types of guardianship non-insurance, just supplementing the son's status. Let's see here. I had a parent tell me that if they get guardianship of their child, that they will not be able to qualify for a Medicaid waiver program, and that would pay the parent as a caregiver and be the payee for SSI. Do you have any comment on that, Melissa? So I think what the question is if you have guardianship of your child, would they still qualify for any of the Medicaid waiver programs or the state waiver programs? I think that that's kind of a loaded question, because there's the MDCP, like there's Medicaid waiver programs, and then there's waiver like CLAS and HCS, and so I think that's another story. But what are your thoughts on that?
Yeah, it's going to be highly dependent on the program and exactly which rules apply. So whenever I am explaining Medicaid to clients and working with Medicaid, the thing that I think is so important to keep in mind is that Medicaid is not this one thing that all works the same. With there being so many various programs that are available, it's going to be highly dependent on what program your child is in and exactly your scenario. At a baseline, I would say no, it's not going to generally preclude an individual from getting Medicaid benefits. But again, that is a much deeper, more detailed question than we're going to be able to answer.
One person that Ginger Mayo, she's with the ARC of Texas, and it's MAYEAUX, but it's pronounced Mayo. She is like a community liaison person with the ARC of Texas. I believe she's out of Austin. She may be a good person to reach out to on that. She just did a presentation for us in the last week on the waivers. We did have a participant that said that the issue is that you can't be the attendant in the class waiver program through the CDS option if you are the guardian. And so we are getting a lot of questions. So one, let me just kind of go back here, and I know we want to get through the presentation. Bear with me one second. Okay, this is a question that we hear all the time. What happens when the parents of the disabled child are divorced? So when it comes into guardianship, could you chat about that for a second?
So with divorce, there's a couple of potential scenarios. So one thing I will tell you, I'm going to kind of jump ahead a couple of slides here to kind of get to a point where we can kind of talk about this, because you'll notice here when it says who can act as guardian, there's an asterisk next to the ward's parents. So when it comes to guardianship, if the parents are a married unit, the court will generally appoint them as co-guardians of the person. In a scenario where someone is divorced, it is usually not the scenario that both people are going to be appointed guardians once the child turns 18. So in terms of the process, there is a requirement that you get one of two things from what we call interested parties. So interested parties in a guardianship are going to be the parents, it's going to be siblings, and so long as we have those two things, if there's no children or anything like that of the individual, those individuals, the parents and the siblings, you are required to either get waivers or provide notice to them. So notice is basically telling that person that has an interest in the individual who you're seeking guardianship over, telling them, hey, I'm applying to get guardianship. Do you have an issue with that? Think about it, they can contest it. So generally speaking, the first step that we always want to do is try to get a waiver. When you're getting a waiver, what you're doing is you're getting that person to sign off saying, yeah, I know you're trying to get guardianship. I'm not going to contest it. You don't need to serve me. You don't have to have a constable come to my house and serve me with paperwork. If we can't do that, then we go to service of notice, where we have to have a constable serve notice on that person, and then that person does have the possibility of contesting things. So if, let's say, you are divorced and one of you is trying to get guardianship and the other parent maybe isn't going to contest it. They say, you know what, it is in the best interest, I'm fine with it. You many times can get them to just sign the waiver. They don't have to be more involved in that. If they do contest it, then that person has the ability, you do have to have them served, and then they can essentially come in and say, well, I know that my ex is trying to get guardianship, but I want guardianship. And then that's going to come down to the court deciding and having to go through that hearing process and that more litigation type process. I mean, technically guardianship is litigation, even if it's uncontested, but when it's uncontested, it's relatively simple and straightforward. When you get into contesting issues, things can get prolonged a lot longer. To kind of put it in a little bit of perspective, most guardianships that I work with that are uncontested, from beginning to end, can go as quickly as a couple of months. The longest uncontested I've had was 6 months. We've had contested guardianships that last 3+ years to get from application to the point of decision. So at that point, if they're going to contest, it comes down to, we go to court and the judge has to decide what's in the best interest of that person.
Okay, and I'm going to let you continue on because we're from a time perspective, and we do want you to talk about supported decision making. But one question that is, do I have to go to court? And so basically, can I do this myself? If I want to do guardianship, do I have to go to court? Is there any way around this?
No, if you're going the guardianship route, you got to go to court. No one can give you the authority to act as a guardian once someone is 18, other than a court of law. Which, again, maybe depending on the circumstances, there are ways to avoid it. And I know that, like you said, we're kind of running a little bit short on time. So let's kind of talk about those ways to avoid it. And these are what we generally refer to as less restrictive alternatives. So before you go that route of saying, well, I need guardianship, like I was saying at the beginning, you want to think about, do I really need it? So what you're going to look at is, what are the capabilities of your child? And maybe in your scenario, there is enough capacity that your child understands what it means to sign a power of attorney. And if you are in that scenario where your child does have the ability, once they turn 18, to sign a financial power of attorney and sign a medical power of attorney, sign a HIPAA authorization, then you're probably going to be able to avoid guardianship. You're not going to have to go to court. You're just going to have to make sure that those documents are in place to allow you to assist in making decisions. The other big one that I was mentioning earlier and that someone had just asked about is supported decision-making agreements, which we're going to talk about a little bit more. Forgive me, Allison, what this is supposed to be at 1? Is that what we're looking at?
Veronica, do you want to just chime in if we have a few minutes to go over? Or how do you want to?
Usually our presentation is 1 hour until 1, but we can say bye to our attendees at 1, and if people want to continue and you have a little bit of time to answer questions, we also can do that.
Okay, so what I'm going to do, for the sake of being respectful of everybody's time, is this slide that you're looking at here gives you a kind of overall list of things that, if it is possible, if your child has the capacity to understand and sign these things, these are all options. If your child has a bank account, if you had it as a minor, you probably were already on there as a custodian of the account. You can do co-ownership of things. You can do convenience signers on accounts. You can have your child sign powers of attorney, but I know a lot of you probably do have questions about that supported decision-making agreement. So we're going to kind of dive into that. And supported decision-making agreements, they can be a really good tool, but I'm always I like to be very clear of what they are not. They are not the equivalency of a guardianship at all. With a supported decision-making agreement, essentially what you are doing is your child is signing a contract with you saying, I'm okay with my parent or whoever it is that they're signing it with. It's not always a parent. Maybe it's an aunt or an uncle or an adult sibling. It can be anyone, but they're signing an agreement saying, I understand that I may need help making decisions, and I'm okay with my information being shared with the person I'm signing this agreement with so that they can help me make the decision. That is the key. It is to help the person make the decision. You are not making the decision for the person. And you do have to make sure that your child has a certain level of capacity to really understand what they are signing, that they understand, I'm signing this agreement and you can help me make those decisions. It does act as a bit of a HIPAA authorization. So HIPAA, if you are unfamiliar, I think most people these days are pretty familiar with HIPAA. HIPAA is the federal privacy law. It tells your doctors, your insurance companies, they can't give your private health information to anybody. So if you have a HIPAA authorization, it tells doctors, it tells your insurance company, I'm okay with you sharing my information with these people. So when someone has a supported decision-making agreement saying, I need these people to help me make decisions and I'm okay with you sharing information, it essentially acts as that as well. So in terms of who can, there is a difference in terms of the capacity level necessary for someone to understand what it means to be signing a financial power of attorney and what it is to have to sign a supported decision-making agreement. You actually have to have a higher level of capacity in order to sign a financial power of attorney. Actually, to kind of give you a little bit of side information, a financial power of attorney is one of the highest levels of capacity that someone has to have in signing any kind of estate planning documents. One of the lowest levels of capacity is actually if you're signing a will. So there's various levels of capacity, which is basically how much do you understand? What is your level of understanding? So in signing a supported decision-making agreement, they just have to be able to understand that they're signing this agreement and allowing their parent, their sibling, whoever they're signing it with, to assist them with making these everyday decisions. So as you'll kind of see, probably the first thing that jumps out at you, like I said earlier, a supported decision-making agreement does not allow you to make decisions for the adult with a disability. It is still their responsibility to make the decision for themselves, but you are there to provide support and assistance and making sure that they understand all of the information in front of them. So if you think about it in a specific way, you want to think about it as, okay, we've signed this contract. I can gather as the helper all of the information from the doctor or from the school. I can do all of that gathering of the information to help lay it out for my child and go through all of that with them so that we can together come to a conclusion on what that decision is. So if you can kind of think through that, you'll see you really need to know that your child has the ability to understand that. And in some scenarios, in many scenarios, they end up not really making sense, but in other scenarios they would. So to give you an example, I have a client who, her son was turning 18, autistic. They were convinced they would need a guardianship, absolutely convinced they needed a guardianship. When we came to sit down together and I really got to know her son and we're talking through things, you can go through questions with him and we were able to sit down and say, okay, when you go to the doctor, do you understand what's going on? Do you understand what X, Y, or Z means? When can you want to have meaningful conversations at that person's level. Okay, so it's kind of like when we're talking to professionals and we say the best way that you know that you understand what something really means is that you can simplify it to the easiest level and explain it. If someone is able to understand that kind of simplification of things, then this may be a good option for them. So you are going to be able to access, if you can sign that supported decision-making agreement, you're going to be able to access all the information and you're going to be able to talk about it with the person and help them in making the right decision for them. There is within here, we talk about this fiduciary relationship. If you're a guardian, you have a very high level of responsibility because you are a fiduciary for that person. Meaning if you mess something up, you can be held responsible. If your state loses a bunch of money because you made egregious errors in something, you could be held liable by a court of law. The supported decision-making agreement, because you are not actually the one making the decision ultimately, you are not technically a fiduciary for that person. You're just part of a support group for that person. But as this says, you do have a duty of confidentiality to that person. So just like in other confidential relationships, like I as an attorney can't go tell my client's information to other people. That would be a breach of attorney-client privilege and confidentiality. You are under that same relationship with your child. So technically you are not really supposed to be sharing information with anyone other than the person that you are within that agreement for.
So we have a few more questions, and this is a good one. I do actually hear this one a lot. I'm going to let you run with it. My husband and I will have a testamentary trust, so our assets won't go directly to our child when we die. One of my siblings wants to make our child the beneficiary on her life insurance policy. How does she designate the beneficiary so the assets go to our daughter in trust? If we haven't died yet, the trust aren't established. Can she just put the beneficiary as the trustee of the Jane Doe Special Needs Trust and essentially create a trust for those assets at that point? No.
So this is a conversation in regards to special needs trusts in particular. So I'm going to kind of sidestep from the guardian for a second to just kind of go through this. But when you have a testamentary special needs trust, I'm really glad that whoever asked that question, that you have that understanding, because that trust does not exist until after you pass away. It is not something that anyone else can give money to on a beneficiary designation, or let's say in their will. You know, your sister can't say in her will, I give money to the Jane Doe Trust in my sister's will, because like you said, you may not be dead yet, that trust may not exist any longer or yet. So if you are in a scenario where you have other family members that are going to be looking at providing for your child, there's one of two things that you're going to want to do. A, you're going to want to create what we call a standalone special needs trust, meaning it's created during your lifetime and it can act as a box to be there for when your sister or your mom or your next door neighbor wants to provide things for your child. A testamentary trust is not going to be the right avenue to do that. And someone can't just say on a beneficiary designation, give it to the Jane Doe Special Needs Trust. That doesn't exist. So that's the first option, is that you could have a standalone special needs trust to act as that overall vehicle for anybody who wants to provide, but it has to be in place during your lifetime. The alternative is that your sister needs to go do her estate planning so that her will does the same thing as your will, where she can create her own special needs trust if she wants to. That's going to be highly dependent on the scenario and the circumstances and how much money they're talking about. But usually the first question that I go through with clients when we're talking about special needs trust is anyone else going to give money to your child? And that right there is going to say, if yes, we really are going to want to have a standalone special needs trust. If no, then a testamentary trust might be a good vehicle for you. But that's a conversation you're going to want to have with your attorney in terms of what's going to make the most sense for you and your family scenario.
Okay, what are the ways that supported decision-making agreements are obtained? Is it only through an attorney, even though it does not go through the court?
So no, you technically do not need to work with an attorney for supported decision-making agreements. There are statutory forms. Depending on the scenario, every scenario is a little bit different. The benefit of kind of sitting down with an attorney is they're going to go through it with you, and they're going to make sure everybody kind of fully understands everything, and they can customize things for you. But is it possible that you can, pull forms from government websites and whatnot? Yeah, there is a form that you can use. It's just what is in your best interest that's going to be a personal decision for the individual, whether or not they want that actual legal advice. The way I like to explain it many times is attorneys don't create documents, they provide advice. So if you're going to go working with an attorney for something, it's not just that you're going down and sitting down and they're going to give you a form. The purpose of that attorney is to guide you and advise you through the process personally. And for some people, they go, I just want the form, and you can do that. You don't have to have an attorney to do a supported decision-making agreement.
Okay, and then we have, do you have a slide that lists the levels of capacity for the different documents, like supported decision-making versus guardianship? Like, is there like a model we can run on? I know all things are different, but.
Truth be told, no, there is no slide in this presentation that contains that information. But if you want to think about it this way, guardianship, you're going to obtain guardianship when someone has the lowest level of capacity. If you're getting guardianship, that means that person cannot understand what it is to sign pretty much anything. If you are kind of a little bit above that and someone doesn't understand when you're signing powers of attorney, you have to have what we call contractual capacity, which is the highest level of capacity. Supported decision-making, there really is no kind of statutory dictated level of capacity, but there's an understanding with practitioners and in the law that it's a little bit below that contractual. It's a little bit closer to testamentary capacity, where you just have to be able to understand what you're signing. You don't necessarily have to understand, like with a power of attorney, I have to understand that I'm signing a document that is allowing someone to manage all of my accounts, and I have to understand what that means. A lot of kids in scenarios where you are considering guardianship are not going to have that level of capacity. Now, that's not always the case. Some people, their child does have capacity and they are just questioning that, but they have the ability to do that. Usually the best advice I give clients is talk to your doctor. So attorneys, we can let you know kind of what the levels of capacity are, but the safest bet to take is go to your doctor and talk to your child's doctor and get their thoughts on things too. Like we said at the very beginning, and all kind of throughout, it's a team effort. It's all about the entire team surrounding you and your family. So if you are able to talk to your doctor in advance, they're going to help too, in terms of saying, you know, based on their experience. And if you're working with doctors, psychiatrists, psychologists, neurologists, whatever the scenario may be, who are kind of used to dealing with these things, they're going to be able to give you really good advice about what they think your child is capable of too. So unfortunately, we don't have a slide. There's no specific detailed explanation in the law of what level of capacity it is to sign a supported decision-making agreement, but it is less than what they would need to sign actual powers of attorney.
Thank you for that. We've got one more. If my son is 19 and his grandmother who passed away last year left him a 529 account and another mutual fund account, can I transfer that somewhere to avoid him losing his SSI? And I think we should joint this question. You go ahead and go first, and then I'll kind of chime in.
So depending upon how much money this is, let's say we're talking about less than $15,000 or $10,000. You can take all of it and put it into an ABLE account. So when the ABLE accounts were developed, and I think you mentioned ABLE accounts a little bit earlier, Allison, but ABLE accounts are the equivalency of a 529 account that were developed specifically for individuals with special needs. And what it does is it allows them to have an account that could potentially be in their own name if they have the ability, capacity-wise, to hold the account and manage the funds. But it prevents them from having that money and losing Social Security or losing their Medicaid benefits. So if it is less than $15,000 that was inherited, usually that's going to be your quickest, best solution. You can roll over 529s to an ABLE account if you want to, but the 529 account in and of itself won't necessarily disqualify benefits. The mutual fund is the bigger issue, because that can, if it's going to place that individual over $2,000, it's going to start disqualifying benefits. So if it's under that $15,000 limit, you're going to want to get that into an ABLE account. If it's a large sum of money, we may be looking at having to go and do a first party special needs trust, which is an entirely another scenario. So that's going to all depend on how much money you're talking about.
And that is something that we can help with. And to your point on the 529C for college as opposed to the 529A for ABLE, so in an ABLE account, the individual with disabilities is the account owner. In a 529 account, like the parent or the grantor or the grandparent or who, they're the account owner. So in a 529C, the disabled individual, the beneficiary is not the account owner. The asset is counted for the owner. So unless the beneficiary is the owner in the 529 account, which you don't see, then the 529C should be okay. But the issue is distributions from the 529C for the benefit of the individual that has disability. So the beauty of the 529A is you can use it for a variety of expenses. It's a very, very long list of expenses that you can use for a disabled individual, including school, as opposed to the 529C really being for education. Okay, so so those are definitely common questions that we get all the time, but we can certainly circle back with that. We have more and more questions. This is an active group today. We're glad you guys have questions.
Guys, it's already 1:05. We wanted to thank you both for being here with us and guide us with this important topic with great information for our parents. If you, I don't know, it's up to you. You want to stay another 5 minutes, answer questions, or the other option, if you can send us, we are going to send information, the slides and everything. So if you have more questions for us, you can send us an email and we, for sure, try to help you guys with the question that you already have and you don't have the chance to listen to an answer. So I don't know, Melissa, do you still have 5 minutes? Or Allison, can you stay 5 minutes so we can end the presentation? It's up to you guys.
Say 5 more minutes.
All right, 5 more minutes and then we end the presentation. Thank you.
Okay, so let's see here. We've got a lot going on here. Okay, this is a good question. And then there was another one. I've got questions everywhere. We'll try to answer them. But so what if I don't do guardianship? What are the things, maybe if a parent decides not to do guardianship, what are the problems that they could run into in the future? And then of course, another question, I'll just bring this to you. I think I mentioned to you before, what if we have an ex-spouse or we don't even know where the person is to serve them or whatever, what do we do in that example if we need guardianship and an MIA parent?
Okay, so I'm going to actually answer your last question first, and then we'll go backwards. In the event that there is someone that is more difficult to serve, you don't know where they are, you do have to prove to the court that you have done all that you possibly can. And kind of like other things that I was talking about earlier, it's going to come down to the court's decision on how to move forward and if they will waive the necessity of that service. So if, let's say, for example, like I see a question here from someone, if the father has not been present, we don't even know where he is, how do we proceed? You have to be able to show the court will have a secondary hearing before moving forward with the actual application hearing, where you have to be able to say, you know, we've done everything we can in trying to contact this person. We are unable to do so. And then at that point, the court is going to tell you exactly what needs to be done. It might be publication. Sometimes you can get away with doing publication in the county that you last knew the person to live in, but ultimately it's going to come up to the decision of that judge once you get in front of him or her and say, we don't know where he is. We've done all of the research that we can, but we just don't know. And then the judge will make the decision as to if we will just waive it, if there's going to be a need for publication. Publication is generally going to be like in a newspaper or something like that. It's just public notice in the area where you last knew that person. I'm not saying that would be what the judge would say in every scenario, but it's going to come down to the individual scenario and what the judge ultimately says in that hearing. And then I think the other question that you had asked Allison, is in regards to if we don't get guardianship and then we need it later on. So usually, like I was saying earlier, what's going to happen is you may be able to go a period of time where, you know, you've been dealing with the same doctors and the same school administrative professionals and whatnot that you've been dealing with for a while with your kids, and they're going to continue to work with you even beyond that person, your child turning 18. And there may just come a scenario where they either a new person comes in, you got to go to a new doctor, and the new doctor knows by law they're not obligated to continue to work with you, and they won't. Or you've got a bank scenario, if there's money in the person's name, or it could be the entire opposite end of the spectrum where maybe it's not your kid, but you're dealing with a parent or something like that, who now we've got a scenario where the person loses capacity, or maybe your child had the ability to manage things and then there's an accident. There's all sorts of scenarios. So if you run into that scenario, that's when, like earlier, someone had asked, do I have to get it when they turn 18? No, you're going to get it based on the circumstances. And if you get to a point where those doctors are not working with you, the school is not working with you, you're going to want to look into that possibility of getting the guardianship, or maybe the possibility of a supported decision-making agreement at that point in time.
Let's see here. Okay, so one of the questions, my child who is turning 18 soon will not have the capacity to serve on a jury if summoned, but at the same time, his capacity is above that of a guardianship. That is a problem with autism. We see that a lot with high functioning autism, and even some ADHD. It's not simple, and not everybody is created equal, and a clear gradation or demarcation does not exist. So if he needs to get an excuse from serving on a jury, can he have a legal leg to stand on if he does not become a ward?
Yeah, I mean, and this is getting into a little bit of a different area of the law as well, because as with so many things, so many different areas of the law kind of combine together and intertwine. But there are lots of scenarios where someone can get, I mean, you hate to phrase it this way, but get out of jury duty because there is a reasonable, there's an expectation they don't have the ability to do so. So
on here with a special needs child actually could get out of jury duty for the simple fact that they have a special needs child that needs care. I mean, that is, I mean, so it does go both ways. And I do think that they have a heart of compassion, and even further with people with disabilities and compromised immune systems and COVID going on there. I mean, there are other thoughts on that as well.
Yeah.
One last thing, and I think we will wrap up. And, you know, we're going to bring this to you guys again. I know that this is a topic, it's like you can't, there's so many questions. And when it comes to special needs planning, it is confusing. You're not alone. There are specific accounts. I mean, today's been about guardianship. It's saying, you know, what do I do if I'm not the guardian of the estate? Then how do I set accounts up and not, you know, and protect their eligibility for social benefits? And the answer is an ABLE account. The answer is special needs trust. There are different types of special needs trust. We do presentations. We and we'll partner back with Melissa to go down the special needs trust highway. There's a first party special needs trust, which is the individual with disabilities direct money. There's a Medicaid payback on that. And then the third party special needs trust, which is what we typically see when a family member is leaving life insurance proceeds or other assets or things like that. It goes typically that. So that's a whole nother meeting, which will take the whole time. But right off, an ABLE account is relatively easy to set up. You can put $15,000 a year. If you have any more than $2,000, you need to have an ABLE account or a special needs trust. An ABLE account can pay for some things that a special needs trust can't. And so that is the reason why oftentimes you need a special needs trust and an ABLE account. And rent is the big one. Rent or mortgage payments, an ABLE account can pay for. So anyway, whole nother ball game, but that is like the cliff notes of that. And we will definitely address that again soon. So Veronica, we've really tried to answer as many questions as we can. We're so happy that you invited us to be here with you today. And Melissa, you did a fantastic job. Thank you for sharing all of this. And these slides are going to be out there for everybody. This has been recorded so we can go back. And then Melissa, if you don't mind sending us your slides. So if I know we had a lot of questions, we addressed a lot of questions. So if you want to send your slides where we can send out for any slides that we may have missed, if that's something that you could do, that would be great.
Yeah, absolutely. And thank y'all for having me as well. It's really been a pleasure. I love talking about this stuff. And I have to say, it's an extra pleasure to work with you, Allison, who just listening to you talk about the ABLE accounts is so refreshing. I work with so many really good knowledge of ABLE accounts, which is actually quite impressive. That I'm not used to.
I work in special professionally. I'm a mom with kids with special needs, so I actually do get it. It is confusing.
It's a lot.
I've been working in it as a professional, so if you ever feel like you're oh my gosh, this is mind numbing, it's hard, and I don't know if I'm coming or going, whether we work in this professionally or even as a parent. So I join you both ways, and I will tell you that you're not alone. I mean, it is confusing. It is complicated. You're not dumb. It is unnecessarily complicated. So, but we're glad you're here, and as many as educational events that we can put out like this together jointly. We've got some cool ones coming up after the first of the year. We're going to do one on letters of intent and how to write one, and we have templates for everybody that we'll give out. So anyway, we've got some exciting topics coming up, but all of the big buzzwords that you hear over and over and over again, we repeat these over and over and over. So if you missed one, we do have a YouTube channel. You can go back and listen, and we will be doing them again. So it'll be great. So thank you. And we're going to just turn
Thank you so much, guys, for this information for our parents and our audience. And like Allison is telling you guys, on January 14th, we're going to be talking about what is the letter of intent. So keep in touch with us, and you have questions, please don't hesitate and send your question to us, and you will receive your presentation. Thank you so much for your time. Thank you so much.
Take care.
Bye.